Hi guys, it's Kathy. I hope you're doing well. I'm 12 minutes late, Fozzie. What are you gonna do? You know what he's gonna do? He's gonna tell everybody to yell at me this whole stream. So Florida made it through, right? It's done. It moved past Florida, so we're good. I know Bill went live, so he's fine. Beverly is fine. So I got one courtroom today besides Judge Fleischer. Definitely he had a good day, so we're gonna go to Judge Fleischer. But the rest are from this one courtroom, and I could have played his whole docket. It was just very entertaining. It's a complete roller coaster. He gets people disrespecting him, then he gets heartwarming, then he gets a couple of people that are funny. Oh, look, I get a pass. Fozzie says I'm allowed to be late today, guys. Fozzie said that I'm allowed to be late. Yeah, I love when men say I'm allowed to do something. Hi, Monica. Wait, one, two. Hi, Monica. I said hi too. Twice, too. Everybody say hi to Monica twice. You know, KS, usually people make their name shorter when they change their name. You went the other direction. Linus makes people do it all the time. No, she doesn't. She just says, that's a long name you got there. And without saying anything else, they just go change it and make it shorter. All right, let's see what we're doing. Let's see what we're going to do first. I hate when I don't have it right in the right folder. I'm sorry, it's in this folder. That's fine. Let's start off slow for you guys.
I would attribute some of this to just some confusion. But Ms. Richardson has zero credibility with this court at this point. For example, the idea that she thought she had to get a job before she shows up at probation, and that she was out looking for a job. Zero credibility with me. She was told to report to probation either the day I sentenced her or if she had a hold after she got through their misdemeanor case.
I don't know, Judge. I've never heard a judge say you have to go to probation right away. Don't they say, like, when you're ready, you can just head on over?
That next day, that Monday, she never showed. Not only did she not show, she's off the radar screen for 4 months. Has a bond. Surety files some sort of weird thing saying she's supposed to appear in county court on the 29th of August. No, she was supposed to appear here. Ms. Richardson should know where she had been last, where she had not done what she was supposed to do on probation, and where she was supposed to show up. The idea that she looked at a list and her name wasn't there, she didn't want to be here. So she left. Then she was supposed to be here last week. The report I received is Ms. Richardson's calling in saying, I want to be in court. I want to be in court. Sheriff says she was involved in a fight and got sent back to jail, which is not what she said to my law clerk when she called here. She didn't really turn herself in. She showed up with her husband, tried to talk her way out of it, expressed surprise when she got taken into custody. All of that is completely consistent, not with somebody who's confused, but with somebody who has a drug problem and isn't dealing with their drug problem. So if Ms. Richardson wants to continue down this path, she's going to end up spending some time in jail where I'm comfortable that she'll have her drug problem addressed. Otherwise, what is a request for the court?
Judge, if I caught the beginning of the court's record correctly, the court is reinstating the prior bond?
Yep.
So
I've got a consent of surety that's appears to me to be good, filed on October 1st, after I did the forfeiture, and I'll set aside the forfeiture. It says reinstatement of the bond.
Judge, then I would ask that the court order her to report to probation tomorrow, as by the time she's released today, I think it will be quite late. And then she would be willing to waive the 14-day rule. And then let me check a date for Miss Landry.
So she's getting out. Does she need to reapply? I thought we were going to have to set for appearance of counsel and status on the revo.
I think we will, because she now has a bond, so she'll get released.
Judge, I was assuming that if
today.
she had ADC, but I guess that's probably more than 6 months. That's fine, Judge. If the court wants to set for appearance of counsel and status.
So, Ms. Richardson, two things. This bond is now being reinstated. This is the bond that I set on the probation revocation, which means that unless you've got a hold someplace else, you should be released on that bond. You need to report to probation, and you need to apply for the public defender. I'm making both of those a condition of your bond. If you don't report to probation and I find out about it, if you don't apply for the public defender and I find out about it, the next time I see you, I'm forfeiting your bond and setting the bond at an amount that you're probably not going to be able to make.
So how you'll
right.
flip? Say it.
Yes.
All right. Not doing it.
He didn't say so high you'll flip. Ugh. Nah. Judge, come on. Get your act together, Judge. All right, another quick one before we go into him. I think I'm going to try to turn it down a little bit. So
I'm
the
not going to
S's,
take her into custody under those circumstances.
see how the S's keep whistling. I'm going to try to just tap it so that the S's don't whistle. Oh, it's not really high. If you guys want me to put it right back up again, I will.
But Judge Brody might, when she sees you next, because you were before her on September 27th with specific instructions to apply for the public defender. And I'm not hearing a real good explanation for why 2 weeks later, you still haven't given all the documentation to the public defender. If you want to be out of custody, I think that would be a very high priority between now and next Friday, that you get all the documentation to them that they are asking for. All right? Because I fully expect that if you show up again before Judge Brody and you haven't done that, she'll fix the fact that you don't have the public defender by putting you in jail, and then they can represent you. No questions asked.
So in Colorado, if you are in custody, you automatically get a public defender. If you hire your own attorney, then the public defender steps down. But you don't have to apply. You don't have to wait. The second you're in custody in Colorado, you automatically get one. So if she doesn't get her paperwork in order, she's going to jail. By Judge Brody. Judge Brody. I know we had Judge Brody on before. I'm trying to remember what he looks like, or she looks like. He said she. Anyway, now we're going to go into, let's just start with the disrespect. Let's just, it's a slow burner, but it gets there.
So, Mr. Brush, you reviewed this waiver of extradition, and it not only is a waiver of extradition, but it's also advising you about your rights based on this.
They're not heathens. They put their names in a hat and they pick one. That's how you know if you get a private attorney or a public defender. Apparently, I don't know why, but apparently this judge does too.
Fugitive warrant. Any questions of the court about your rights? Any questions of the court about your rights? You understand this? You don't need me to further advise you, I guess is what I'm asking.
Yes, I understand.
All right. And then you want to waive extradition?
Yes.
All right. Court will sign it, noting that he is waiving extradition. Date it today, the 10th day of October, 2024.
And Judge, that timeline is what I wanted to actually address briefly with the court. Because I'm essentially going to be asking if the court can effectively nunc-pro-tunc this waiver back to September 26th.
Watch your mouth.
And I can explain why.
Okay.
So, Judge, if the court has had the opportunity to look at the fugitive case packet, on page 2, it references extradition notes that were put in place by Sergeant Zumowski. I don't know, I've not ever interacted with that sergeant before, but there's essentially a conflicting information as to what happened on the 26th. Mr. Brush came into custody on the 25th and was almost immediately sent to the hospital for pretty severe medical issues. He's actually been in the hospital since then as well. Essentially, the jail is really struggling to manage his blood pressure. He's supposed to be on very specific blood sugar, very specific insulin and other medications on a road cycle, and that's not really happening. His goal is to try to get out of, basically to go and deal with this warrant as soon as possible. And that is why he's willing to waive extradition. This document claims that he refused to sign a waiver, but he was in the hospital. There was no refusal. I think this is stock language that was put in and that he was never actually given the opportunity to waive at that time and has now since been in custody an additional 2 weeks without kind of being advised on these rights or having the right to waive. And so I'm just concerned that because of what appears to be either a clerical error or something erroneous that was put in by this sergeant due to Mr. Brush's hospital status, he's now going to be waiting even longer for Arkansas to pick him up. So I'm asking that the court essentially run that 30-day statutory deadline for Arkansas's pickup from September 26th and to set a court date in 2 weeks for that deadline.
I hear from the people.
I tried to make him bigger.
I have no document what happened. I know today is his very first. I and have testimony on that.
You can hear what the people have to say better
Mr.
soon.
Brush, please want to address the prosecutor directly.
Well, I guess we have a disagreement, Mr. Brush, between you and the people.
Hold up. Don't let the court finish.
So here's the issue, Mr. Brush. Based on the information that I have before me, and I agree with the district attorney, we could have a hearing on this. But the documentation I have is that on the 25th, it says that you were sent to the hospital, but it also says that you were ready for an extradition interview and that it was conducted and that you refused to sign a waiver of extradition. I understand you dispute that.
Conducted where?
The way I read it, it would have been either prior to you going to DHMC in an ambulance or there. I don't know. In any event, I got what you say through your counsel, and I got what's in this document. And I can't, Mr. Brush,
Let him finish.
if you want to argue with me, you're going to lose the argument. The guy in the black robe always wins the argument with the guy standing out there. Okay. And if you want to be intemperate with me, that won't help you either. If you want to listen to me, you might learn something. Do you want to listen to me?
Are you talking? I'm talking?
Mr. Brush, do you want to listen to what I'm about to
Mr. Brush was saying, are you talking? Are you talking? I know it's hard to hear.
tell you? Or do you want to be held in contempt of court? What you're doing, Mr. Brush, is causing me to think I may believe that sergeant over you, because probably you mouthed off to him too, but we'll see. If you want to have a hearing, then we can bring the sergeant in. I'll hear what the sergeant has to say, and I'll hear what you have to say. And
Colette, that's what I thought too. How dare you say intemperate? That's just rude. I'm not intemperate.
I'll make a determination of whether you actually were willing to sign the waiver at that time, and it didn't happen. Arkansas can moot this by picking him up from whenever the date is.
And Judge, that was going to be part of my reason for.
Love, no, shut up. The judge just got done yelling at him. Why are you about to talk right now? Don't, just be quiet for a second.
Requesting
Nope.
a hearing on a status essentially on the 25th anyway. The statutory timeline is 15 days to 30. So we'd be at 15 from today if the
Thank
timeline
you.
runs from today. I think past the 30 if it was from the 26th. So I think in any case, it would be helpful just for docket management purposes. If he is picked up expeditiously, then the case can be closed. So if the court would accept a brief setting on 10/25, that would be my request.
She clearly just said right now to the judge, my request is for a brief setting on 10/25. Remember that.
Let me just double check something. I think I can accommodate that if,
Oh, now who's being intemperate, judge? Or green, depending if you're male or female. I'm so sorry, Colette.
Judge, there is one other thing that I did want to point out to the court. I don't know whether the remedy that I was requesting in terms of the nunc-pro-tunc would make a difference at all on Arkansas's end, since I know the court can't control that. What I can tell the court, though, is that if the court looks at page 10 of the fugitive case packet, understanding I think Mr. Brush has been waiting for me to call his case all day, and he and I are on the same page. I'm going to do the talking. We've had some good conversations today. I apologize, Judge. I think it's just late. That page, Judge, is the proposed waiver. And normally when somebody refuses, because these cases go in front of Magistrate Beckman, and there is no right to counsel when those, for those individuals who are advised in 2300, it's Miss Montoya will be happy to talk everyone's ear off about how much of a problem it is over there. But when someone refuses, generally it's listed as refusal is written, and here it does not say that. It says an @ symbol and then DHMC 92624. So I think that does suggest from Mr. Brush's part that it is very possible that there may have just been an error in terms of how this was entered, and that because of his hospital status, they just created a fugitive case instead of bringing him back to 2300 for either a waiver or a refusal of a waiver.
That was a good point she made. You know what, Lori? It's fine today, but guess when it's going to be bad again? I know it. Guess what day it's going to be terrible again? Tuesday, October 15th.
I do see that. Thank you. So, I can add Mr. Brush for a hearing on the 25th, late morning, if everybody's available.
I can accept that.
Your Honor, I hesitate about late mornings. I have a flight in the afternoon.
I take these eye drops, but they taste so funny.
Early afternoon. I need to be gone.
I could also set you first thing at 8:30. But I have 2 pretrial conferences that morning, so I was going to try to work you in. And one of them is with a pro se defendant, and I've already.
It would just be lovely if everybody else who went down to Judge Fleischer's courtroom on the 15th would also scratch one of their eyes. That way we're all in it together.
Anticipated that that's going to be a fairly lengthy pretrial conference.
And Your Honor, is this with the testimony of Sergeant Sumowski?
If necessary.
All right. If I can...
In other words, if we have to have a hearing about the significance of this date difference, on the other hand, if Arkansas wants to act on the waiver of extradition and come get Mr. Brush, we don't have to have a hearing about it.
Judge, my request is that if the court notes and I guess the order to the sheriff's department, and I don't know what kind of orders typically the court, or if anything, the court transmits to the sheriff's department so that they can let Arkansas know. My request is just to have the timeline reflect that it was running from the 26th. If the court is declining and saying, I don't believe Mr. Brush, I think he refused to waive with the record I've made.
Counsel, I'm not doing either of those things, as I tried to explain to Mr. Brush.
Okay.
I'm not doing either. I'm not believing him, and I'm not believing the sheriff, because I don't have the sheriff here, and he hasn't, and Mr. Brush hasn't testified under oath. So that's what the hearing would be about, to make that decision. If Arkansas comes and gets him, who cares?
Sure, Judge.
Did he waive the extradition 10 days before, or did he do it now? If it turns out it makes a big difference, that's what the hearing would be about. I thought that's what you asked for, was a hearing on that, because I can't decide who is right here without a hearing.
Okay, Judge, no. And maybe I was unclear. What I had asked for is the court to make the decision to not pro-tunc it now. I understand the court is declining. What I was asking for is a status as to his pickup. I can talk.
I'm saying status and hearing, because we have the status, and if he's wrong, Arkansas has more time. If he's right, Arkansas didn't act on it. I don't notify anybody about the waiver of extradition. The district attorney does. The district attorney now has the waiver of extradition. The obligation falls on the district attorney to notify Arkansas that there's a waiver of extradition if they want to come pick him up. That's the way I understand it works, despite what the statute says about the court notifying the requesting state. As a practical matter and as the way it works administratively, the district attorney notifies the state he's waived extradition. You could come get him. And there's a statutory and there's a time frame within the statute by which that has to happen. I would point out, if they don't come pick him up, I think the remedy is they can request the fugitive warrant yet again. Not fugitive case gets dismissed, never to be refiled. But I don't know. Never had it come to that.
Judge, the reason I was asking for the status is because I believe, based on my experience with these fugitive cases, the remedy is that the case is dismissed and he's released, and Arkansas will need to re-request a warrant. So I want to make sure that I'm on top of his potentially getting released if Arkansas chooses not to extradite him on this forgery. So I think more or less all on the same page. I will look into and speak to Mr. Brush about whether we want to have himself or the sergeant testify. If we can set in an abundance of caution for status in a hearing on the 25th, I will be here at 8:30. That works for Ms. Bell.
I'm trying to reach Sergeant Sumowski to see if he is available, although I would note, I think that based on 1619, 119.5, there is a period of time we have after the court order, which has started today. And I don't think that there is really a lot of sense in a hearing when there simply was no court order before today.
Well, I'm glad that both of you don't think there's any sense in a hearing that I'm setting.
I apologize.
Mr. Brush is not the only one being disrespectful of the court in that sense. We're having a hearing on October 25th. Get the sergeant here, because if the sergeant doesn't care to show up, I'll probably make a finding that Mr. Brush wanted to waive extradition back on that date, and he's got that much advance notice. And then I'll fix this waiver of extradition that he filed today by doing something like a nunc-pro-tunc back to the date that he wanted to waive extradition and get out of Denver back to Arkansas. Although I don't know why he wants to go to Arkansas. To fix this.
You're not going to tell the judge anything further.
To fix this.
Mr. Brush.
Mr. Brush, I apologize to you. I've got a very short memory. By the time this rolls around for a hearing, I won't remember our little discussion.
Okay, Mr. Brush, please don't say anything on the record as to your case. Judge, I can call.
It's status and hearing on the fugitive warrant.
And Your Honor, sorry, first, I want to apologize. I absolutely recognize what I said was implying that the court's hearing was silly, and I did not mean it that way. I apologize. Second, Sergeant Sumowski can be available. Is it at 8:30?
8:30.
Okay.
You're good, Mr.
Okay. Now we go from that and we go switch gears completely. Completely switch gears. This is interesting.
On behalf of Justin Friedberg for the people.
And a little
And
sad.
Bernanke,
but
on
not
behalf
that
of
sad.
Mr. Friend, who appears in custody. These cases are set for sentencing today, Your Honor.
I mean, it is sad, but it's not like someone died and you're crying.
Parties ready to
Heartbroken.
proceed on sentencing and resentencing.
We are, Your Honor. I do have some paperwork for the court to review. It's just admission into Stride Sober Living, a letter of support from his MAP program advisor, and then a letter that Mr. Friend is going to read to the court. And I also have a copy for the court,
All right.
if I could approach you.
Yes, you may. Any amendments or corrections to the PSI?
Yes, Your Honor. First, there was some indication that they couldn't complete, I think it was a full treatment level score for this case, and they indicated that Mr. Friend refused to do the ASR. In speaking to Mr. Friend, even before he was sentenced, I wasn't there for, even before he pled, I wasn't there for the plea itself, but we were in divert court. We were in courtroom 1H when the competency evaluation process was going on.
Real quick, Lorraine McLaughlin, are you representing Ireland today or are you here in the States?
And they told him and me that they were going to indicate that they were still accepting him into divert and that he didn't need to do another divert assessment. So what he indicated to those evaluators was, I've done this already. It should be in the court file. He wasn't refusing to do it. There is a letter in both of the revocations indicating that they will continue to take him if.
Yes. Guys, we have a lot more Canadians that watch this channel than you think, but they're never in chat. And there she is, representing. Can I have some maple syrup, please? Please, please. Hi, Vibe lurkers.
The court deems it appropriate to resentence him to divert. So I did just want to make it clear that divert is an option for him in this case.
Any amendments or corrections on behalf of the people?
Not that I'm aware of, Your Honor.
I'll hear first from defense counsel, then from the people, and then I can read this letter to Mr. Friend, from Mr. Friend, but he also has the right to verbally address the court if he wants to do so. Before you start your argument, counsel, let me look at these documents. Other than the letter, I'll save the letter till
I
the
love
end.
them.
All right. You can proceed.
Yes, Your Honor. Your Honor, I would say that Mr. Friend, for someone of his age, has maybe made the most profound work I've seen of anyone in custody for this length of time. He, at only 20 years old, even when he first arrived in custody, immediately accepted responsibility and indicated to me that he needed more structure. He told me that he knew he couldn't do probation without structure, without inpatient treatment. Initially, his request of me was to ask for a community correction sentence on this case, but that wasn't something we were able to negotiate with the district attorney, and he had an open plea in front of him and in front of the court. And so he took the time on his own to apply for Stride Sober Living to get.
I'm not going to lie, Fozzie. As soon as you said, I'm not going to tell you what I use it for, the first thing I thought of being in Texas, being down south, is chicken and waffles. Fozzie eats a lot of chicken and waffles.
Into that sober living program. And now we are making a request of the court to give him another chance at divert, but with Stride sober living as possibly a condition of that sentence. If the court were to give divert, we would be asking the court to give him a jail sentence and let divert work with Stride Sober Living, so he would be released directly to them. He actually, through the application process, was able to get a scholarship for at least 90 days free of charge. And his goal is to work and be able to pay to do continued inpatient treatment past that amount of time. I think part of the reason I think that this work that he's done on himself and these realizations that he's made are profound is because not only because of his young age, but because of the lack of structure and support that he's had his entire life. He has had more trauma than most of my clients have experienced. He, as the PSI indicates, his father, he has no communication or interaction with his mother because about 2 weeks after he was born, she went to prison. She has struggled with substance abuse and mental health issues. as well, and he hasn't really had any communication with her. His father similarly has been an addict pretty much his entire life. As Mr. Friend notes in this PSI, his father was physically and verbally abusive. They also lived with his grandmother who had mental health issues along with his father, and he was the subject of their mental health episodes, their anger, their mistreatment of him. Despite all that, he's told me that, his father's doing better. His father's, getting sober. He still communicates with his father and has him in his life. And that's despite the immense trauma that he inflicted upon Mr. Friend at a young age. If the court can tell in the PSI, it indicates that he used marijuana for the first time at 8 years old. That was because his father used it and introduced it to his 8-year-old son. At 13 years old, he was taken away from the home. He was put into a group home. And at around 13 or 14, he ran away from that group home and spent a majority of his time on the streets and spent that time homeless. I should have thought of how to introduce this to the court, but I have psych evaluations that he had done when he was when he was younger and when he was in juvenile detention. And one of the things those evaluations mention is that he had been subject to, he'd been shot 3 times on the street before he was the age of 17. What I thought was immensely surprising about that is Mr. Friend didn't even think to mention that to the PSI evaluator, because that was just trauma that he had experienced and not even realized, or remembered that he had gone through. And that's just because he's dealt with so much. And also because I think in a lot of ways, he hasn't been someone who's used his trauma to make excuses for himself. Instead, he's tried to take care of himself, and he's tried to do the things that he can in his life to get past what he's dealt with. As the PSI indicates, he also has a host of mental health diagnoses himself that he has struggled with his entire life. He was on an IEP when he was younger. He has chronic ADHD, bipolar disorder, anxiety, and depression. He did try to take his own life when he was first put into the group home and when he was living on the streets. And despite this, he is honestly, one of the kindest, funniest clients I've had. He's a joy to be around. As a court can tell, his MAP program counselor talks about how well he's doing, how hard he's trying. He has a case manager in the jail. He has a good relationship with his case manager. He talked about how he's been able to get information online about sort of barber hairstyles to do, and he does hair while he's in the jail. He's practicing and working on that. That's why he has goals to go to cosmetology school. He mentioned some of it in the letter he's going to reach at the court, but he also talked about how this MAP program has helped him deal with his impulsivity and how he's going to use it to sort of not relapse again like he did in this case. He talked about how, in this case, he, was impulsive in, actually don't think it's mentioned, but the reason that he kind of struggled with divert is because he had housing with a friend. That friend was using, and so he left to live on the streets. He got back together with a girlfriend who used, and he made the decision to use again. And he talked about how he's going to stay away from her going forward and what decision he would have made if that opportunity happens again, which is to go to one of his sources of support, or as he's planning on doing, go immediately into treatment and have them to support him in not making these impulsive decisions. He talked about how he sort of used this in the jail. He had incidents where he's like, when someone comes up to me and they're angry and they try to fight with me, I take a deep breath and I walk away. And that's not things I would have done before, but it's something he, has really internalized and is using now. I just, seeing that trauma that he's struggled with, and seeing that at 20, he's not making excuses. He's hoping the court gives him divert, but he understands and is also indicating that community corrections, he'd understand why the court would give him that. And the structure of that would also be, of immense help to him as well. I think one of the interesting things I read while going over the psychological evaluation that was done of him when he was a juvenile is they talk about how sort of the meth use and the marijuana use at a very young age impacts your brain, impacts development, creates a lot of difficulty, having impulse control. But they also say that William presented as a kind young man who was eager to work with his evaluator. He was engaged and demonstrated the ability to persist even through some cognitive fatigue. With appropriate supports and treatment, he has the capability to reach his goals. And the fact that the evaluator could see this themselves, they talk about in this assessment that what he really needs is he needs access to these grounding and mindfulness exercises, how to deal with his anxiety and with his trauma. And those skills can help him reduce these impulsive behaviors. And what he's done in the 8 months that he's in custody is on his own realized that and gone to the resources he needed to get that treatment. I know that he's been given a chance to divert, and I know that it appears to the court that he's been given these multiple chances and that probation is not appropriate. But I think that because he got into the sober living program on his own, and that he specifically is asking that he only be granted divert with the condition that he goes into this sober living program and starts with that stability, I think that is a new plan. And I think it's a plan that makes a lot of sense. I also know that the district attorney is going to talk about, the number of motor vehicle thefts that he has on his record, and the fact that they do incorporate eludings. I do think it's important to know that the eluding in this case, it is not an excuse, but it was speeding from a undercover cop car. It is not a situation where he hit somebody else, he went off of the road, something like that. And I do think that he has turned to these motor vehicle thefts in the same way that other people turn sometimes to selling drugs to support themselves on the street. His father is actually in custody himself now for a motor vehicle theft. And I think it indicates that he's been taught the wrong examples of how to make income and take care of himself. And I think now with these resources he's gotten, like I said, he's working towards a barbering. Cosmetology school is how he's going to make money. He also was talking to me about other positive things he does as hobbies. He's talking about how he loves crocheting, which he learned in juvenile detention. He will continue to do. He enjoys riding his bike. He was also talking about multiple other positive things he plans on doing. He likes puzzles. He likes hiking. And he's really thinking about what he's going to do when he gets out, not to kind of hang around with the wrong people on the streets and to continue this cycle. So I asked the court to grant him one more chance to divert on these matters. And if the court is not willing to do that, to give him the minimum community correction sentence, which would be 4 years in this case, Your Honor.
He's going to read a letter, but it's not long.
For the people.
Your Honor, Mr. Friedberg is ultimately asking for 10 years in community corrections on the 24 CR 643. He would then ask for 6 years of community corrections on 23 CR 4415, concurrent with that other matter, and then 18 months on the 23 CR 2355, also a concurrent community correction sentence.
I'll do it right here. Just do it right. All you gotta do is type it in. It'll just take a second. Nobody will see.
Ultimately, I think his record speaks for itself, and he's never been successful in probation. I think the fact that he's had the opportunity for that more supportive probationary term on, from what I could tell, both regular probation as well as the divert probation, it's clear that the divert probation and obviously regular probation is just simply not enough for him. I think it is clear that Mr. Friend has really had a lot of people fail him in his life. And did not have the upbringing that he should have been entitled to. But ultimately, I think the community corrections is an appropriate outcome in this matter. Again, Mr. Friedberg is asking for 10 years. I can say that I went on a tour of the Moore Center and Project Elevate this week, and I was describing it to people as it reminded me of college for people learning to major in how to be a productive adult, because with the layout of it and the way it was set up is very much in a dormitory style, but also with classes that you would go to for CBT, for addiction, for life skills, for all of these things that Mr. Friend sounds like probably was never taught by a parent or guardian, that I think he would really benefit from, as well as the intensive treatment, the mental health staff that they have, the mentors that they have. I think he needs to be in a more supportive environment, and with speaking with participants of community corrections, that is what that program can provide for him. So we'd ask that you sentence him to the community corrections.
And Your Honor, just really briefly, I think Project Elevate is actually.
I know that's a females thing.
It's not available to men at this time.
Those are the only two we could go to.
So in case you didn't hear that, all that good stuff, the dorm room, the classes, it's just like college. It's only for girls.
All right, Mr. Friend, anything you wish to say to me?
Yeah, I just wanted to read you this letter.
I've got it right here. You want me to read it?
Yeah,
Or do you want to read it out loud?
I'll read it to you.
All right, I'll read along.
Understand, Your Honor, I don't really expect a slap on the wrist. I wanted to go to divert with patient treatment program as a condition or ComCore because it will give me the help I want and need. I do want the structure of an inpatient treatment program. I mean, I got out, I got on divert. I thought I could comply with the outside world. Ended up struggling on my own. I ended up getting evicted from the apartment I was staying at with a friend because the company I was using drugs in the hallway. We ended up getting kicked out. So I didn't have a place to keep my stuff. It became harder to comply as I made some mistakes, and ultimately I was back on the streets. I just wanted to apologize for not being able to complete the divert when you guys already gave me a chance to do that. I was accepted into sober living. I didn't know I could go to sober living for free before when I was on divert, so that's why I ultimately never went, because I didn't know. I thought I had to pay for it, and I didn't have any money to go. And so I was asking for another structure, another chance to do that so I could go to work and know what it feels like to earn a living. And during my time here, like being incarcerated, I've learned a lot about myself, what I can do different to change. The things I've done wrong. I want to take this opportunity to go to sober living and divert so I can participate in treatment and therapy. I do want to go somewhere in life. I don't want to keep this pattern going. I want to end the cycle, Your Honor. I just wanted to apologize to the victim and to the community. I wouldn't want to do that to my community. I have learned through my classes and treatment how much this affects the community I came from. I would not want to see someone else doing that and that kind of behavior in my community. Now that I've been in the MAP program, I can see that stuff that way and see what I've done from a different perspective. I understand why the consequences for crimes like this are so high, and if I were to be given another chance, I would do something with it.
Your Honor, I just want to let the court know too that he worked with both his Elbert County attorney and with me. He spent a lot of time trying to think about how to express his ideas. He wanted us to type it up for him because he was, gets nervous and was unsure if he could express them correctly. But he's taken a lot of time to think about the best way to express the responsibility he wants to take. And he took composing this letter seriously.
Thank you.
Same
Yes,
with
Your Honor.
Pennsylvania. So beautiful. Your audio is fine. He's thinking.
The court notes that the status report for the divert court that was filed and is to pending revocation cases says that should the parties in the court agree that Mr. Friend is still appropriate for probation, the divert court program is willing to continue working with Mr. Friend. Sounds very much like they're looking for unanimity and they're not getting it. The people aren't agreeing to divert. I'm not agreeing to divert at this point. I don't think divert is best for Mr. Friend. Mr. Friend has done well while he's been in jail. And his letter An attachment to the PSI, I think, acknowledges he needs structure. A sober living program is sort of a self-imposed structure. We're not going to keep him there. He don't want to be there.
Yeah. I just picked a certain one because they do classes and stuff like that. That's the only reason I wanted to go to that specific one.
We say both interchangeably. I need structure too. I need a structured settlement.
Mr. Friend, I think that what you need though is
yeah,
you're right. You need structure. And I think that the next level of structure for you is ComCore.
Yeah, I'm fine with that.
So the question then becomes the length of ComCore.
Mine's about 250 in the winter.
So I'm very hopeful that ComCore will accept Mr. Friend. I don't see anything that would necessarily prevent that. Other than potentially the Elbert County case.
They will sentence him a concurrent ComCore if he gets that here. There's already sort of an understanding.
All right, good. And I don't want to be, Mr. Friend, I don't want to be too vague in my language here when I say you need the structure of ComCore. You need the structure and our community needs to protect against you stealing cars. I don't think, and I don't know when Mr. Friedberg came up with this. I think I've already been on record telling him 10 years in community corrections is a non-starter with me. The only reason you would do that is if you think he's going to fail and it's an easy change of address to the DOC for a very lengthy amount of time. And in my view, if he fails at ComCore and the people think he should get 10 years in DOC, then don't ask for just a simple change of address. Ask for a resentencing hearing at an increased sentence, which is allowed under the statute, but which would take into account why did he fail at ComCore? I don't sentence anyone to ComCore with the expectation that they're going to fail.
Yeah, I can't afford to fail.
I think, Mr. Friend,
Shut up, dude.
You can be successful in ComCore.
Yes.
So I'm going to structure this a little bit differently than what I would if I thought that Mr. Friend would get into ComCore relatively soon. The last I had heard, everything's going to be better. We're going to get people in almost immediately this summer. As far as I know, didn't happen, hasn't happened. So,
want to know the pre-sentence confinement calculations on the cases?
I'm sorry?
Does the court want to know the pre-sentence confinement calculations on them?
Well, I need pre-sentence confinement credit on the 2 resentencings.
those are, I'm calculating a total of 455 days on the 23 CR 2355 case.
Did you say 450 days?
55, yes. And on the 4415 case, I'm seeing 389 days pre-sentence confinement credit. And I do think the PSI is slightly off in that it doesn't account for, I think, the time since it was calculated. I think he actually has 254 days for the new case.
254.
That's what I'm seeing. Okay. Maybe one of those date calculation things.
Well, it says he was arrested on the 31st of January, and now it's October 10th.
Is that wrong? I just inputted it into.
No, we're probably pushing more than 270 then.
Oh yeah, I'm getting two. Wait, no, I'm putting the date wrong.
This 240 sounds about right.
Yeah, I don't know what I'm putting it in the date calculator online, and it is saying 131 to 1010 is, I don't know, maybe it's calculating it wrong. 254 days.
Oh no, that sounds right then. I was counting 90.
That's certainly facially reasonable from that date. So 254 days. All right. So this court will sentence Mr. Friend as follows. He's resentenced in 2355. His probation is revoked. He's resentenced to community corrections for 18 months with 455 days of pre-sentence confinement credit. In 23 CR 4415, he's resentenced to 5 years in community corrections with 389 days of pre-sentence confinement credit. And in 643, he's resentenced to 5 years in community corrections with 254 days of pre-sentence confinement credit, all to run concurrently. There's no restitution in the case to be imposed. 5 years is on the outer end of what I would sentence somebody to community corrections. Frankly, about 3, maybe 4 years, depending on how much pre-sentence confinement credit they have, they're either going to get what they can achieve out of community corrections or not. But in Mr. Friend's case, with the amount of pre-sentence confinement credit he has and the amount of time it is likely to take before he is actually into community corrections, a 5-year sentence is going to start off 4 years, and then he's going to get substantial credit going forward. I think that will, with 5 years, it will at least give him some structure for a more extended period of time. So, Mr. Friend, you won't serve anywhere near 5 years because you already got almost a year of it served with 254 days of confinement credit. You'll get credit until you're actually accepted in community corrections. And then you build up credits pretty quickly. But this will give you some structure going forward. I hope they'll place you in a good program for you. And my assumption is they will. They typically look pretty closely at somebody and decide where the best place for them is. The problem isn't the placement decision, it's getting somebody into community corrections. So that will be the sentence of the court. And as I said, all of those sentences will run concurrent. think that's all. Good luck, Mr. Friend.
So just remember, there's jail, there's prison, there's probation, and then there's ComCore, community corrections. And the judge can't just sentence you to ComCore. ComCore takes a lot of time. He's in jail right now. Not prison, he's in jail, I think. So he's going to get credit for all the days that he's in prison. He's already been in prison like 400 some days. They're giving him credit for 200 and some of those days already. So the prosecutor wanted 10 years in ComCore, and I don't know if you were bored and distracted like I was, and you missed it when the judge said, "Don't ever ask me for 10 years of ComCore," because it's a non-starter for me. I'm never going to give someone 10 years of ComCore. So he gave him 5 years, which is a lot for this judge to sentence someone for ComCore, but he knows that he's already served like a year of it already. And he's also going to serve way more until he's allowed to get into ComCore. So once he gets into community corrections, he's locked up. And then he works his way up through levels to get more and more freedom. Like after a month of classes, he can get a job and then he'll get out for work release. And then, after a year goes by on work release, he can do overnights somewhere outside and he'll work his way up to being out in the community. So hopefully he does well. I think he's going to do well. I think this little kid's going to do well. Okay, I got one more from this judge, and it's not that long. It's not like that one we just saw. But we're going to learn something. I've never heard of this before, ever, 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 ever. I thought it was funny. It's interesting anyway. I've never heard of it.
And if counsel would state the disposition for the record.
It's my understanding that he's going to be pleading guilty to an added count 2, a drug felony 4, contemporaneous consumption distribution with 2 years of probation, no restitution, immediate sentencing. From what I can tell, this is intended to be a wobbler. Yes, Your Honor.
A wobbler. This is a wobbler, guys.
Mr. Dyer, I'm going to ask you some questions. Please answer all the questions out loud. Speak into the microphone as you do so. Ms. Pernickle, if you want, you want to upload them to be part of the file, that's fine. So I'm going to ask you some questions. Please answer them all out loud. If you don't understand one of my questions or it's not clear to you, let me know and I'll clarify it the best I can. Would you please state your full name?
Gary Dyer.
Are you the defendant charged in this case?
Yeah.
How old are you?
38.
How much education have you had?
In the 9th grade.
Are you understanding me as I'm speaking to you here this afternoon?
Yes.
Are you clear-headed today?
Yeah.
Are you taking any prescription medication? Have you consumed any other pills, drugs, or alcohol in the past 24 hours?
No.
Do you suffer from any mental or emotional condition that makes it difficult to understand what's happening here today?
No.
I'm going to repeat the proposed disposition of your case to make sure that you're understanding as well. You would plead guilty to an added count 2, distribution of a controlled substance, a level 4 drug felony. On that guilty plea, count 1 would be dismissed. That is a higher level felony that would be dismissed. The proposed sentence is 2 years of probation and an agreement that this case is what is called Wobbler eligible. Not sure where Wobbler came from, but what it means is that if you're successful on probation, the sentence, I guess, wobbles down to a misdemeanor. Maybe that's what it means. That's probably me making stuff up. But the intent is exactly that. Success on probation, it's reduced to a level 1 drug misdemeanor rather than a level 4 drug felony. So have I accurately stated the disposition of your case?
Yes.
And is this how you wish to proceed?
Yes.
Have you discussed it with your attorney?
Yes. He's 38 years old, guys. Poor guy.
Attorney.
Yes.
Are you
Poor girl.
satisfied with her representation?
I don't know. It's gonna be a girl.
Yes.
Then with respect to added count 2, which is the level 4 drug felony of distribution of a controlled substance, contemporaneous consumption, what is your plea, guilty or not guilty?
Guilty.
Before I accept that plea, I need to make sure you understand the rights you have, but that you give up when you plead guilty, as well as the effects of pleading guilty. Plea agreement addresses both of those things. I see your initials throughout the document. There's also a number of NAs indicating that those paragraphs don't apply. And then an electronic signature for both you and your counsel. Did you authorize your counsel to add your electronic signature to that document?
Yes.
Had you read and understood it before you gave her that authorization?
Yes.
I'm going to go over your rights, Mr. Dyer. You have the right to be represented by a lawyer at all stages of a criminal case, not just at this disposition, but all the way through trial as well. If you were determined to be indigent and couldn't afford a lawyer, one would be appointed at no cost to you. You have the right to a jury trial, which must be held speedily. That means within 6 months of a not guilty plea. Be a public trial at which you'd have the right to have the charges proven against you before you could be convicted. At trial, you'd be presumed innocent. You wouldn't have to prove anything. Instead, the burden would be on the district attorney to prove all elements of a charge by beyond a reasonable doubt to the satisfaction of a unanimous jury. At trial, you'd have the right to remain silent. If you exercise that right, it would not be held against you. But you'd also have the right to testify. That would be a choice to make if you went to trial. You'd also have the right to call witnesses and have those witnesses subpoenaed to appear at trial, and the right to confront any witnesses who testified against you by having them cross-examined. And if you were convicted at trial, you'd have the right to appeal the conviction to a higher court. Do you understand that other than your right to counsel, you give up all these rights when you plead guilty?
Yes.
You understand that by pleading guilty, there will be no trial in your case?
Yeah.
All right. I also have the elements of the charge to which you're pleading guilty. I again see electronic signature for both you and your counsel. Did you authorize having your electronic signature added to the elements of this level 4 drug felony?
Yeah.
Had you read and understood it before you gave that authorization?
Yes.
By pleading guilty, you're admitting the elements of this offense and giving up any defense you have to this charge. You're subjecting yourself to penalties provided by statute for committing the offense. The penalties for a level 4 drug felony are 6 months to a year in the Department of Corrections, a fine of between $1,000 and $100,000. And any sentence to the Department of Corrections also has 1 year of mandatory parole. Mr. Dyer, other than what has been said to me here in open court, have any other promises been made to you to get you to plead guilty? Is anyone forcing you to enter this plea? Is this a decision you're making freely and voluntarily?
Yes.
Mr. Dyer, this is what you have decided to do?
Yes.
Is there a waiver of factual basis, counsel?
Yes, we waive.
Mr. Dyer, do you still wish to plead guilty to the added count 2, distribution of a controlled substance, contemporaneous consumption, a level 4 drug felony? Your plea is accepted. The court will make written findings regarding the acceptance of the plea. Judgment of conviction on added count 2 enters. Count 1 is dismissed. And is the request for immediate sentencing?
Yes, Your Honor.
I'll hear first from defense counsel, then from the people, and then Mr. Dyer, if you want to address the court before I impose sentence, you may do so. You're not required to. It's up to you, counsel.
Yes, Your Honor. First of all, Mr. Dyer does apologize for the failure to appear last week and is incredibly grateful that he was able to add on today. Basically what happened, I think, is the quick turnaround kind of got away from him and he completely forgot. He called me on Wednesday and was like, I think I have court on Friday. And I said last Friday. So that he got in here as soon as possible. And he does appreciate being seen. Mr. Dyer and I have been able to have several conversations about his case. I think he is feeling a little bit hesitant and nervous to be back on probation, but he has completed it before, and I think he will be able to complete it again. He has the support of his father, as well as other family in the area, and has been working incredibly hard to kind of move forward in his life despite this charge, and is really hoping that he can benefit from probation going forward.
Thank you. I'll hear from the people.
I have no further record.
Mr. Dyer, anything you wish to say to me before I impose sentence? Mr. Dyer, I'm going to accept this disposition, vacate the warrant that was issued when you didn't appear last week. I think that was held over at least until Friday, but then went into place. So that we'll vacate the bench warrant so you don't have a warrant out there in case you get pulled over or something and they think there's a bench warrant and they take you into custody. So that's vacated. Otherwise, I'll agree that this is an appropriate disposition. Sentence you to 2 years of probation. Terms and conditions will be decided by probation when they meet with Mr. Dyer. No restitution. And we need to set a Wobbler review date for Mr. Dyer. So it'd be 2 years out.
Or his day on. So he's got a Wobbler plea. So that means in a couple years, if he's good, is this which would scare me, because the first day I'm on probation, I'm going to violate by accident. I'll accidentally commit a murder or something and lose it, and I'll get arrested again, and then I'm going to get nailed for the entire full sentence twice, probably. I don't know. But if he gets it, a Wobbler he has a felony right now. He's a felony charge of drug something. I think distribution. I think I kind of lost track. But if he completes this couple years with no problems, it gets bumped down to a misdemeanor, so he won't have a felony on his record, which is pretty good for him. Well, Lori gave a great explanation. Wait, where's Kelly? We'll see, Lori. We'll see how you're doing compared to Kelly. Here we go. Oh, this is Louise. Are punished consistent with felony or misdemeanor standards. In other words, a Wobbler can be punishable either by a term in state prison or by imprisonment in a jail and or by a fine. Up to the trial's discretion. Oh, that's Cornell. What do they know? I'm looking to see if Lori typed something because I was told to find Lori. No, unless I completely missed it, which I'm blind as a bat, so maybe I did. Oh, you said Louise. Can't read. Okay. Look at his tie. Popping. Out of that whole screen, that tie is like whoosh. So we have some fun in Judge Fleischer's court today. If you didn't see it yet, gets kind of good, and then it gets kind of. Is he muted? Sure is. He sure is muted. Start there. No. Nope. I'm not getting into color discussions. Apricot.
Judge, may I briefly approach?
Yes.
Just want to introduce you to our newly licensed attorney, Rogette.
Hi,
Judge.
newly licensed.
Yes.
Congrats. How does it feel?
Say her name.
It feels like I can breathe again after 5 months.
All that work.
Except, minus the congestion and everything.
treat the practice well and it will treat you well. You know,
Say her name.
it's great. I mean, there's no better profession than this, you know, and anytime I speak to someone who's wants to do it, I wholeheartedly encourage them because really there's no greater profession.
I don't know. I heard trashmen get some good shit on the job.
It's great.
Yeah.
Well, welcome. We'll have fun. You'll learn a
Thank you so
lot.
much. I'm excited to be in your courtroom, Judge.
Thank you, Judge.
Counsel-
Judge, yes, I'm here for Adrian Razzo's first appearance.
This
I hate fighting with people who are just wrong.
is an arraignment.
Yes,
Do you mind bringing them up?
yes, Judge. How you doing this morning, Judge? I'm well, thank
Been a
you.
while.
It has been a little while. I was excited when I got hired.
Hey,
Coming back in.
oh, we're happy to have.
Counsel, do you guys have arraignments? You're doing arraignments first?
Sorry, guys, let me, we'll try to blow through them. You're Adrian Razzo. Mr. Razzo, you're charged with harassment. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On October 2nd, 2024, officers were called to a residence and spoke to the complaining witness who stated that the defendant is her ex-boyfriend. The complainant stated the defendant moved out a year ago on August 15, 2023 after an argument. The complainant stated that the defendant came to the location on September 1st, 2023, grabbed all his belongings and hasn't been back since. The complainant stated on the date of the offense on October 2nd, the defendant started texting her saying, "If you don't change the locks and let me in the house, you will regret it." Also, the defendant continued to text intimidating messages requesting paperwork and the deeds to the house. The complainant asked him to stop texting and to leave the location. The defendant refused to leave the location and kept calling and texting the complainant. The officer observed the defendant parked at the end of the driveway, preventing the complainant from parking there, and the defendant remained on scene while the officer was there, never exiting his vehicle, and he was seen occasionally turning his car on and off. The officer observed approximately 30 calls and 25 text messages from the defendant while the officer was on scene.
While the officer was
And Mr. Razzo, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of
This
your
was
bond
you.
not to have any contact with this person. Do you understand? I'm ordering you also not to go within 200 feet of where this person lives or where this person works. If I find that you violate this, I'm going to put you in jail. You will not get any more PR bonds. I'm going to protect every single person in this county. I don't care what you think. I don't care how you feel. If you're kicking and screaming that we have to put you in jail, it makes no difference to me. Do you understand? You have a great lawyer. It's your responsibility to stay in touch with him, and he will tell you when you have to come back to court. I will waive your appearance so I don't have to waste your time. But like I said, if you pick up a new case, violate any of these conditions, into jail you will go, no more PR bonds. So do you mind filing no contact, no weapons, and then we'll have him sign it? Okay, so I'm gonna have him sign a reset. We'll have him wait in the jury box for the bond conditions and free to go.
Very good. Thank you, Your Honor. Thank you.
Yes, sir.
Thank you.
Leslie, are you ready?
Yes, sir.
McIntyre, come on up. Page 15.
Christopher McIntyre. Mr. McIntyre, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Yes, Judge. On October 5th, 2024, officers met Webster PD and a witness following a possible DWI at 14835 Sun Harbor Drive in Harris County, Texas. The officer observed the defendant, the driver of the vehicle, pull into a garage off a public.
John, it's your mother's birthday today. Is that right? Was that you? Yes. Is it your mom's birthday? Tell mom we said happy birthday. Also, it's Brian C's birthday. I don't know if he ever watches my channel though, so but it's his birthday. If you see him, Fleischer's yesterday. Happy yesterday birthday. See Brian C in Fleischer's court today. Say hi to happy birthday to him.
Roadway. The officer made contact with the defendant and observed the strong odor of an alcoholic beverage. The defendant, unable to follow instructions, red glossy eyes, slurred speech, stumbling while walking, and poor balance. Standard field sobriety tests were refused. The defendant was read the DIC and refused breath and blood. The will witness stated she witnessed the defendant fall off a motorcycle twice, and the defendant was swaying and unable to maintain balance while trying to pick the motorcycle up. The will witness stated they went through.
He's on a motorcycle, driving it, and he falls off the motorcycle twice?
Yes, Your Honor. And the will witness stated that they went through 2 red light cycles as well before the defendant drove off. The will witness followed with hazard lights on, driving 70 miles per hour in a 35-mile-per-hour zone to stay within eye contact of the defendant, and was on the phone with 911 the entire time. A blood search warrant was obtained and executed.
I see that he had a prior
I'm so
DWI
glad
dismissed
we're
about a year and a half ago.
finally.
What else? Alex, what other criminal history do you see? Anything?
No other besides that dismissed DWI.
I'm gonna find probable cause, but I'm debating whether to put an interlock on him. That has me pretty worried, Mr. LeGrand. You know? Mr. McIntyre, I'm going to find that there's probable cause to go forward with the case. For the time being, I'm ordering you not to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I'm going to put you in jail. You will not get any more PR bonds. If I find that I can trust you and that you're not going to consume, then we can talk about taking it off. But for the time being, I mean, this is really scary, man. You're on a motorcycle and, you know, God forbid something happens that you tear your head up, you know, really. I'll pay for it for you so that there'll be no issues for you, but for the time being, no alcohol. If I find that you're using, and I don't care what the source is, cakes, candies, foods, gums, energy drinks, tequila, lollipop, paradigm, whatever it is, we will not give you any more PR bonds. Do you understand?
Sir.
Okay. What do you do for a living, sir?
Manager of IT.
Of what?
Manager of technical services for blood.
Okay.
IT.
Got it. All right. You've got a great lawyer. Listen to him. He will take care of you. I will waive your appearance because you have a lawyer, but you must stay in touch with Mr. LeGrand, and he will tell you if when you have to come back to court. If he tells me he can't get a hold of you, then likewise, I will revoke your bond. Be careful out there. You have but one life. And on a motorcycle, it's, you know, my wife is a nurse and she calls it kidneys on wheels because so many accidents and you get into one. I mean, really. Okay. I'll have you sign a reset with Victoria. After that, I'll have you with pretrial. So we'll have you sign the bond conditions. And after that, you'll be free to go.
Judge, can we go ahead and at request permission to travel? He does have a trip coming up, and I don't know if you are doing call-ins or not.
We do for the time being.
Okay.
You know,
he's going to Japan with his wife. It's they're getting married. That's their wedding trip. And it's, what are the
when are you
dates?
going? And
10th to the 24th. November 10th.
I will allow you to go, but understand you're still under bond condition of this court. I don't care if you're in Abu Dhabi, wherever you are, you're not allowed to consume alcohol or legal drugs, and you're going to get tested the minute you arrive back. So beware. No means no, and I don't care where you are. Okay? All right. Please. So we'll let Ms. LeGrand, we'll let them know now so that he's not going to get called between those dates.
Okay.
All right.
Thank you, Judge.
Please.
Right this way.
And if you can file the guardian interlock report,
It's in
please.
there, Judge. Page 5, Pierre.
Victoria's currently using it right now.
Yeah, 3 days. Yeah. Or you know what? When did he say his trip was? Okay, yeah, 3 days. And then waive the fee. Yes, on all DWIs, no drugs, no alcohol, random analysis, and then I'll tell you if there are any other changes. What was your last name, sir?
Yeah, Pierre.
C-A. That's it, Pierre Cia.
Yes.
So, Mr. Cia, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Apologies, Your Honor. Can I get the last name, how to spell it?
C is in cat, E-A.
I think it's.
You want a cause number?
Can we confirm the cost number?
It's 253-2145. Don't say anything, please. We're about to do probable cause. Anything you say, they're going to use it against you. Now's not the time. Okay.
On October 2nd, 2024, the officer was dispatched to a major crash at the 2400 block of West 18th Street in Harris County, Texas. The witness, a Houston Fire Department employee, stated he observed the defendant asleep at the wheel, the defendant's vehicle on with the key in ignition, and the vehicle in drive. The witness stated the defendant mentioned drinking earlier in the day. The officer made contact with the defendant, the driver of the vehicle, and observed red glassy eyes, a moderate odor of an alcoholic beverage, incoherence, poor balance, and standard field sobriety tests were attempted. However, the defendant was unable to follow the stimulus during the HGN, and thus the standard field sobriety tests were not completed. The defendant was read to DIC, and a blood search warrant was obtained and executed.
DWIs. I see the one that was dismissed
It was just
10 years ago, but
no other DWIs, Your Honor.
Mr. C, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you have a Texas driver license, sir? Do you have valid liability insurance in your name? I'm ordering you as a condition of your bond to obtain and not to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, you will go to jail. You will not get any more PR bonds. You understand?
Yes, sir.
Okay. We're going to reset your case to give you time to hire a lawyer. There's a lot of timing requirements with the DWI, so I wouldn't sit there and wait a month or 2 months because you're only hurting yourself. You need to be in touch with a lawyer really quick. I will have you go to Victoria, sign a reset. After that, we'll get you with pre-trial for your bond conditions, and after that, you'll be free to go.
Thank you, Your Honor.
Please, sir. Did you check a license?
Fuller.
Can you run up, please, Alex?
It's eligible.
Good.
Did she use her initial remarks?
Stephen, what? Okay.
Mr. Fuller, Your Honor.
Good morning, Mr. Fuller. Mr. Fuller, you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
The complainant's husband is a plaintiff in a civil suit against the defendant. And husband and defendant were engaged in a Zoom deposition. Deposition on October 2nd when the defendant.
It's husband and wife, and they're suing each other?
Yes, Your Honor.
Stop.
Order in the court.
Okay.
This will be
Sounds
interesting.
good. Continue.
This is a complex
Yes,
case.
Your Honor.
Let me jump
Wonderful.
in. really
Finally.
quick. Okay, so this defendant is a defendant in an ongoing civil suit. The plaintiff in that civil suit is married to the complainant in the defendant's criminal case.
Say it again.
Okay, so the complainant in this case, this is Rachel. She is married to the plaintiff
Okay.
in the civil suit against the defendant.
Okay.
So it was during a Zoom deposition that was happening between the parties, and the defendant logged off early, and he stated that he had to go to a hospital, I think because his daughter might have been in the hospital. And I'm going to refer to the husband as the plaintiff, if that would help. There's a lot of parties, but the plaintiff.
So Rachel's husband.
Yes.
Okay.
Rachel's husband, he asked Rachel to basically check and see if the defendant was telling the truth. So he asked Rachel to park on the defendant's street and basically follow his car. And then the complaining witness, Rachel, followed the car. She saw the defendant pull into a nail salon and drop his wife off at the nail salon. And that is when the confrontation happened. The complaining witness, Rachel, she began recording the defendant. The defendant saw her. The defendant got out of his car and he threatened to shoot the complaining witness. The complaining witness began driving away and the defendant followed her with his vehicle until the complaining witness was able to get away.
What's the suit about?
It is, well, I only have what the plaintiff told me and the complaining witness, but they told me that this defendant defrauded their company. I think he's the CEO of like a hedge fund. And just to let you know, I believe, I was told that there are also pending federal charges in this case from the Department of Justice related to the defrauding.
Oh, that they're,
Not in,
has federal charges pending?
Yes, Your Honor.
Mr. Fuller, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have contact with this complaining witness. Do you understand? When I mean no contact, I mean no contact in any way. Phone calls, text messages, Snapchats, anything like this. If you're in a deposition and you're in court, that's something else. But don't try to have any contact with this person. You have a lawyer, correct?
Yes, sir.
Okay, hold on. No. I don't want to talk about anything because right now you really could hurt yourself. So if for some reason you have to have contact with these people for any reason, use your lawyer. That's why you have a lawyer. The lawyer is there to protect you, help you in every way that they can, right? So for any reason, if you have to, anything regarding them, use your lawyer. Don't do anything on your own because it's just going to go sideways real quick. And I'm going to tell you now, I'm going to protect every person in Harris County, and I don't care what the reason is. I don't care what you try to justify it as. I'm just going to put you in jail.
That's our next arraignment.
Kid
Okay.
goes with you.
You understand?
Yes, sir.
Okay. Can I have you, do you have a lawyer now?
Yes, sir.
Who's your lawyer?
Michael Pham.
Oh, that's right. Okay, so because you have a lawyer, I will waive your appearance, so you don't have to waste your time coming to court. But you have to stay in touch with Mr. Pham, and he'll tell you if and when you have to come back to court.
Yes, sir.
Now, have you go sign a receipt with Victoria. After that, I'm gonna have you take a seat in the jury box where we get your bond conditions, we'll have you sign it, and after that, you'll be free to go. All right? Please. So you can file no contact and no reference, please.
Yes, Your Honor.
How many more arraignments do we have?
She was the last one, Judge.
Okay,
I'm gonna take a bunch with me on the 15th, and I don't even know if Steven's gonna be able to handle these babies.
if you want to start helping them out so we can, you know. Oh, okay, anyone? Come on up.
Go ahead and approach.
Hey.
Mr. Osborne, who's not on the docket, he's. Good morning, Judge.
Hey, good
He
morning.
forfeited back in May. He's in holding over.
Oh, he's in jail, okay.
The lawyer for the bonding company here. I lost contact with him. He's a high school student.
I don't,
Numbers I have.
Osborne? I don't see an Osborne.
He's not on your docket.
Sorry, Your Honor, I have the cause number.
Beverly, you don't know how lovely it is to see you. I'm glad you made it through the hurricane. I was just a little bit worried about you.
Yeah, sorry. It's 247
Okay,
9571.
there we go. So where is he now?
He's here. He's
He's
in
in
custody.
custody, okay. So I have his bond at 10,003 because he takes off a lot. I mean, I don't,
If I could, we actually, I represent A Better Bail Bond. A Better Bail Bond, there was an original forfeiture, I think, back in like March. A Better did the bail bond for him because he was captured in Griggs County. A Better Bail Bond neglected to notify him of the May court date. That's the reason he did not come to that second court date.
I have multiple court dates that he hasn't appeared though, not just one. I've got at least 3 different times that he's failed to appear. At least 3.
I know he did prior to us
I mean,
representing.
there's no way that I'm going to give him a PR bond. Just, can you get Mr. Osborne, please?
He is a
Stephen?
high school student. He's still in
While
school.
I'm getting Mr. Osborne, do you want to knock out Ms. Moore real quick while the child's quiet?
Is she here?
Yeah, she's
Yeah.
ready to
Oh,
go.
Yeah.
Yeah,
Let me,
and that.
while we get, let me do this so we can help her out and then.
Page 16, Moore.
Good morning, Miss Moore. Come on up. That's a cute baby. Oh, Lord. And now we have a case that's 1,300 days old. Ms. Moore, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. Hold on a second. Have we done PC on this case? I think we have.
Check the notes, Your Honor. I don't have anything in the notes regarding.
Let's do it real quick. You have charged with assault. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man. Okay.
Yes, Judge. On April 10th, 2021, officers were dispatched to an assault that just occurred. Upon arriving, the officer spoke with a witness who had video footage of the incident. In the video, the defendant and the complainant were arguing, and the defendant can be seen spitting in the complainant's face. The defendant then slaps the complaining witness, and the complainant hits the defendant back in an attempt to defend herself.
Who's the complaining witness?
Any witness is
Have any with the relationship?
a neighbor.
Ms. Moore, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have any contact with this person and not to be in possession of weapons. You understand? Okay. What do you do for a living, ma'am? What do you do for a living?
I'm a stay-at-home mom right now.
Okay, I'll appoint your lawyer today. Do not go anywhere. Your case is 1,300 days old and it's time to do something. So I'm going to have you talk to a lawyer today. We can just have you wait there. If the baby gets loud, please take her outside, but we'll have you talk with the lawyer today. Okay. Okay. I don't know about signing a receipt yet because it's 1,300 days old, you know, so if we just reach out to the MAC, please. All right, ma'am, please. If you can file no contact and no weapons for now.
Mr. Osborne, I had a PCI agreement worked out back in February. He is a high school student. The phone number I had for him got disconnected. I couldn't reach him, which is why he ended up forfeited. I guess they picked him up where he lives now with his mother in Gray County. He's a high school student. I'm just saying, like,
You have taken off on me 3 different times, Mr. Osborne. If you think that we are going to give you a PR bond, you are charged with assault, bodily injury. You're facing a year in jail. You had an offer in this case where they were going to dismiss this case, and you have repeatedly taken off, not once, not twice, but thrice.
Jazzy was looking for you, Shannon, in Fleischer's court yesterday morning. She hasn't seen you in a while.
I am not going to give you a PR bond, and we are taking you into custody now. Your bond is now set at $10,003 because of all the times that you have taken off. And I get that you're in high school, but the problem is that you have already taken off 3 times. If I let you go now, what does that tell you? What? It tells you that it's okay for you to do what you're doing and not to hold you accountable. And that's not what we do here. You need to understand that courts are here for a reason. We do court orders for a reason. And when you fail to comply, when you fail to show, there are real world consequences. And I don't know if you have anyone that's going to bond you out. If not, you will be stuck like Chuck with me until this thing is over with. And I'm going to tell you now, I'm not into this pleading guilty, time served just to get out, just to ruin your life. I'm not going to let you do that.
we accepted the PCI. The state said they would still accept the PCI.
I get it, but I'm not letting him out.
Actually,
I mean, it's 3 times the case. How old is this case? It's a year old, and
you set your bond at 10,000.
I can't wait, Victoria.
well, I don't know, because whatever they're going to charge you, I don't know. You're a flight risk. They may charge you more.
I asked a question.
Sure.
I don't recall leaving 3 times.
You have a criminal case. You know that you are supposed to keep up with it. There's no out of sight, out of mind. You should have enough wherewithal to say, you know what? I haven't had court.
Oh, you don't do it yourself, yourself. This ain't the place where you ask questions, okay? All right.
You should have enough wherewithal to know, you know what? I have court and I haven't heard in a long time. What's going on? The only reason you are here now is because what happened?
But bonding company's attempting to get the case reinstated and or a new bond set for them. That's it. We wanted to let the court know it was our fault for not notifying him of
I'm
the
not
May
going to
setting.
all of the sort. It's not your
I
fault.
do understand. Yes.
You know, if it was one time, okay.
Hey, I mean, when I'm mad at you, that's one thing, but when you got Victoria, oh man, you in trouble, Fozzie. Victoria, I want to see it though. I want to see it happen. She lives in your town, buddy. All right, nowhere you can go, Fozzie. Nowhere you can go.
But we have 3 different times. It's unacceptable. Okay.
If I may.
Sure.
He did miss court 3 times, but he missed the first one because I couldn't reach him because the phone number I had was disconnected. I reset it 2 more times to try to get in contact with him. So he didn't purposely miss 3 court dates just because I couldn't, the phone number I had for him.
He knows he has court, Mr. Schofield.
I understand.
You know,
I'm just-
Trust me. I would way rather the judge be mad at me than Victoria. Yeah, I'll take the judge any day.
behavior has consequences. And now you're going to see that there are serious consequences to it. He goes with you.
Your beer's gone. You got feelings
Guys.
now, don't you?
I'm not out for blood. But I want him to understand that we mean business. If he is unable to make a bond by tomorrow, then we can talk. And I'm happy to entertain perhaps something tomorrow. I get it that he's in high school, but I want him to understand that we mean business. And if I just let him go now, it's enabling him. And it's not a good thing. But I'm happy perhaps tomorrow, if he's unable to make bond, we can talk about a PR bond tomorrow.
Should we just set him for review for
He's
tomorrow?
going to come back tomorrow regardless because they'll auto-populate.
Okay.
Because that's what happens when we take someone into custody, they auto-populate for the next day. So we can talk about it tomorrow about, because I'm not going to let him plead guilty just to get out and just to get a conviction on his record. And I'm happy to do this, but I want him to understand that we mean business and we're not playing games. So if he's still here tomorrow, we can talk about doing a PR bond and we'll let him try that. But I'm going to tell you now, he gets an ankle monitor, curfew, and I'm going to drug test him. And I'm going to be his dad. That's it. Okay. All right.
Thank you.
Hi. Hey, of course.
How are you today?
What's up?
I am approaching on Uceda Zelaya. UCEDA.
I'm sorry I'm not wearing the jacket, Judge. It's just hot here. Sit right here.
I'm happy you're here. I'm not happy you're here, though.
Thank you, Tom.
Better him here than not here. That's what I'd say. You'd be even more upset if he had failed to come.
Well, it'd be easier.
Also,
You failed to report for a drug screening on 9/26. I'm sending you now for a drug test, Mr. Mendoza. You know what's expected of you. You know what's not expected of you. I'm sending you now. We'll see what happens. But you ever miss again, I will issue a warrant for your arrest. No questions asked. Do you understand? When they call you to take a drug test, you are expected to go. So just take a seat. We're going to send him now. And then depending on how it comes up, I'll call you.
well, if we're sending him now, shouldn't we just send him to, is it 49 same send him?
Yeah, but we got to do the order.
Oh, okay.
So
All
it's
right.
going to take, because they're working with the
Understood.
arrangement first. So,
Have a seat, Mr. Mendoza. Do not leave until they expressly tell you to. All right, have a seat. Yeah.
and I'll text you. You know, Mr. Akers, I was going to give you the benefit of the doubt as far as meth. Shh. Hey, we need to talk. As far as meth, cocaine, amphetamines, ecstasy, THC, I was going to give you the benefit of the doubt on all that. Because I know, because you tested positive just a couple days ago, that you were probably going to test positive today again. But alcohol is a different story. That doesn't stay in your system 2 days, 3 days. No, no. And I'm going to tell you now, Mr. Akers, the days of catch and release, done. Guess what happens now?
Thank you.
So I think that at this stage in the game, because we've had so many issues with Mr. Akers, I think probably a TRAS is what we need to do to figure out how we go forward here.
Yes, sir.
But I think that I'm going to do, Mr. Akers, Mr. Akers, I'm going to do everything in my power to help you. I know that you're not going to like it, and I know that you're going to go kicking and screaming, but I'm going to tell you now, that's it.
No,
It's done.
absolutely
And
not.
I'm not going to take anything because I want you to get the help that you need. You understand? Okay, goes with you.
And I also.
There's nothing, no justification you can get.
Good morning, beautiful.
10,000 more. The day she left.
I understand. Well,
So how do you prevent someone from going to Walmart?
I don't know. I mean,
I have an idea, but I don't think we're allowed to do it.
well, the allegation is, yeah, 10 bottles of motor oil, and I thought it was maybe a refile.
Walmart has been asking that about my sister for years. Okay.
No, this way. We don't want you by the prosecutors. What are you doing with yourself these days?
Looking for a job, but they don't want to hire me, but not really.
Tell me, what is the last time what have you done to look for a job?
What have I done?
Yes.
I went to the internet. I told my sister to go through the stuff. They only hire pipe.
Why you tell your sister to do it?
I'm really not good at that. I don't think you really understand.
You need to learn how to use a computer.
They told me.
Did you just hear the judge, Fauci, or is your video off? Did you guys see that? Sorry. I thought that was hilarious.
Then I went to a friend of mine. Well, she's not really my friend, but she told me she could try to help me out. Cooking wings. That was my last resort.
Go there and ask them for an application and apply. Why haven't you done that? We've set this case off for 3 different times now. What have you been doing with yourself all day, every day? If I drug test you now, what's going to show up?
I came up cleaner with it.
I'm sending you right now. You've got me concerned the way you're acting right now, Mr. Gallindo. I'm sending you for a drug test. You must come right back. If you fail to go take a drug test, you take off from me. I'm going to make your bond extremely high. Do you understand? Take a seat. Who's next?
That's it. Yeah.
Okay. You mean You want to go and then I can text you? You want to go and I can text you or?
Yes, I'm about to finish up, so.
Okay.
Mr. Galindo, have a seat in the back.
Patrick,
I'm really concerned.
lots of people haven't seen it. Okay, everybody saw it.
You need me to stick?
I'll call you. I have your number. I'll call you and then you can always zoom in. That way you don't have to just stick around and wait.
After that, okay.
Well, I don't know. We'll see. He's got to have it done. Got to be here at the next setting. We'll send it for.
Look at that. Got it. Okay.
Good morning, Mr. Vidales.
Morning.
You know, believe it or not, we want to help you. But we need to have you evaluated. And every time we try to do that, you don't let them do it. The quicker way to get out is just talk to them. Let us know what's going on. And once that happens, we can work to try to get you released.
Man, I got my plans. I got like 1,000 deals going out of the free world. I got about 10,000 deals.
And I
going
want to
out.
help you get to those deals, but can you help us with do the report?
I already did the report.
They said you wouldn't talk to them.
I did talk to them. They were asking me stupid Y98 questions, all types of stupid questions. I got 8 apartments. I got 8 bandos. I got 10,000 deals going on. I got all types of. I'm leaving Broadway. I'm not going back to no Broadway. I'm going to Honduras. I'm going to El Salvador. I'm going to Tokyo. Fuck Houston. I'm not staying in Houston. Houston is bullshit to me.
Oh, Houston's great. It's
Houston
hot.
is bullshit to me.
Why?
It's always been bullshit.
And I love my town. It's just too hot. But other
I'm
than that,
leaving
it's
it.
great.
So can you please just let me go?
If you talk to my,
I already talked to them. I did talk to them.
but they told me you started acting up, then they couldn't talk to you because
Started
you,
asking me stupid. I'm gonna scare them back up again. I'm gonna scare them back again. I'm gonna scare them back again. I'm gonna tell them stop asking me stupid questions.
I mean, we're not gonna do anything until you talk to them.
That's a
people.
misdemeanor. That's a misdemeanor. Misdemeanor is 24 hours in jail. That's a ticket and a warrant.
How long you been in jail?
I've been in jail for 4 months. My charges are for 2
Was
weeks.
it 24 hours?
My charges are for 2 weeks in jail. Walgreens got their own policy.
Look, I want to help you out.
Walgreens got their own policy.
Talk to
If
them.
I steal $5 from Walgreens, that's ticket and a warrant.
Quit interrupting the judge. Listen to what he has
If
to
you
say.
talk to them.
Talk to who? Right now?
The doctors that come to see you.
I'm starving at this point. I'm starving. I eat $150 a week. I'm only ordering 1 bag of coffee. I'm starving. You got me sitting down looking like an idiot, starving.
Look, no one's looking at you like that.
I'm the one who's starving at this point. I could eat 10 chicken soups and 10 bags of chips, cheese, and then a whole bunch of coffee and chips and sodas and then water. I'm starving at this point. I'm starving. You got me sitting like an idiot, starving.
If I get you the food, will you talk to the people?
Right now?
Well, it's gonna take a little bit of time.
You're gonna get me resetted again.
If you talk to them, we'll work to get you out. But be
I'm
nice.
not gonna talk to them. I'm refusing. I'm refusing.
And I'm gonna set your case for trial then. We'll go to trial. If you're found guilty, then we'll just do the DDRP.
For what? For a misdemeanor?
Yeah. You keep picking.
I'm not gonna even take it to trial.
I'm gonna put it to trial.
How are you gonna put a misdemeanor to trial?
3 cases, and we can do one after the other. And if you're found guilty, at that point, we'll just.
I'm gonna drop off there. I'm gonna act a fool. You can punch me down and put me back in.
Come on.
Come on, Mr. Vidal. Let's talk about it. Come on. All right. Go for a plus.
And that's what it's like having a teenage boy.
Here we go.
So the thought process, instead of the TRAS, is do a competency because maybe they can make a determination based upon the behavior or what they experience and when they do their evaluation.
Perhaps do it right after lunch. You know?
Savage. Ooh.
Is he on his medication? Do you know if he's taking medication? Perhaps let's schedule it for a time where he right after he takes the medication.
Schedule competency or the TRAS?
Comp,
yeah.
yeah,
TRAS
no,
is that
not
question.
TRAS is just, right,
Yeah.
no. At this point, I'm with you on the comp, that's what we have to do. But you have to do it in
And
a
some
strategic
coffee.
way, right? When he's got a big belly, taking the medicine, and he's happy, that's when you do. 30 days, I guess.
She ain't got no ramen in her house.
So comp's been filed. Yeah, I filed that. As soon as we. yeah, we filed that.
Okay. Good luck.
Thank you, Judge.
Can I approach, Your Honor?
Yeah, sorry, sit in the studio. I'll hit you up next.
Jessica Smith.
Yeah.
This is the PTI agreement. It's been scanned
Hey, Michael, can you file on Jessica Smith? Are you ready to file the supervision order? They've sent you the contract.
So, no, Judge, they can't just send me directly the contract. They send it to Brenda.
Okay, so let's set it off a week then.
A week?
Week.
Okay, thank you.
Okay. All right, Mr. Cedillo.
Good morning, Judge. Judge, I have an off-docket matter for Anthony Mann. I've got the cause numbers in the chat. Basically, Judge, he tested dirty and he's set for some BVRs and
And I'm really happy with this man. It's really good. Mr. Triplett, come up.
More
I'm
Aaron?
gonna send up your test today. Good job being negative. Great.
Yes.
I'll make you a deal. You have 3 things left. You have a parenting class, gun safety class, and 100 hours of community service. If you get the gun class done and the parenting class done within the next 3 weeks, I'll kill all your community service hours. 100 hours I'll take away. You've done really, really well, and I'm really proud of you. Great job, staying clean, getting your stuff done. Wonderful, it's great, really. And I'll kill 100 hours. That's a lot of time that you would have to otherwise do. Really, great job. Just keep up the good work. It's great, you know? You have 1 week done, 1 week left of SOP, then you're done with that. And I'll make you a deal. When you're done with those 2 classes, I'll take you off probation. You're done. You'll be off paper, right? Get it done. Just those 2 classes left, finish that one thing. You know, can you get it done in 3 weeks?
Yes, I have to pay $200
Okay,
this Friday
okay.
for the next Monday, and then that'll be complete with the payment. Then I have to log into the next class. And I take the gun safety class, it was only like 4 days long.
Okay. The minute you're done with both of those classes, I'll take you off. Community service, who cares? But make sure there are no fees too. Huh? All right, you're doing great. Just keep it up. You're in the home stretch. Okay, great job. All right, just hang tight. All right.
What about
Brothers? Vassal Adrian? Judge, since there was a little break, did you want to put the discovery thing on record?
Are you ready, Ramon? Yeah,
Yes, Judge, I'm ready.
okay. Who's gonna talk to the state?
And would you like my client up here?
Sure.
Mr. Hall? Yes.
Okay.
We have a defendant here where I think that they've absconded. The name, Wanna Bail. They've absconded and can't take off.
Wanna bail.
So their name is Wanna Bail.
Yeah, you want a cause number?
Looks like they did bail. They wanna bail and they did bail. Go ahead, Judge.
231-9264. Two, three, 92.
I just see that case, Judge. Looks like discovery is complete.
Okay, anyways, okay, so last time.
Hall.
All right, everyone, we are going on the record. Please do not talk. If you have to talk or say anything, please go outside. All right, we are on the record in cause number 249-7988. Today's date is October 10th, 2024. It's approximately 11:20 in the morning. Guys, if you'd please identify yourselves for purposes of the record.
Michael Haddad with the state of Texas.
Shreya Gulamali for Kieran Hall.
And the reason we're here today is Mr. Hall has been charged with driving while intoxicated. The case is 199 days old. And today we are set for a discovery compliance hearing regarding information on blood. From what I understand, blood was taken as a part of evidence in this case. Defense has repeatedly requested for evidence regarding the blood, specifically search warrants. And I'm going to let state, tell me what have you done as far as trying to get the information?
Judge, we've made diligent efforts to request a search warrant in this case. Our first request was on February 29th. That request was completed by our administrator on March 28th of 2024, in which Baytown Police Department advised that they don't show any search warrant on file for this case. We further made repeated efforts recently this month, specifically on the 24th of August. We emailed again to re-request a search warrant. Baytown got back to us again stating that they don't show any evidence of a search warrant in their file in this case. Further, on 10/9 of 2024, we called and emailed Baytown Police directly to discuss getting us this residual search warrant for this case, and we've received no response thus far. And as of today, 10/10 of 2024, the state does not have in its possession any search warrant for this case.
When the blood was initially taken, was it taken pursuant to a search warrant?
No, Judge, this was hospital blood that we provided, we obtained a residual search warrant for. Because there was such a length of time after the accident, we never drafted a standard blood search warrant where we would take them to JPC and draw them ourselves. We just took the blood from whatever the hospital took when they tested him.
One clarification on that. I think while they didn't do it at JPC, they did draft a search warrant for blood analysis, which was denied by the magistrate. And then they redirected them to do a residual blood.
Right, the blood warrant, and that was because of the length of time. So at the end of the day, the only thing we had was a residual search warrant that was filed and signed.
Response?
Judge, just to put on the record, I did file my discovery request 3914 on April 3rd, 2024. I did also follow up to email the DA specifically about the search warrants on April 3rd, 2024, June 10th, 2024, July 15th, 2024, September 23rd, 2024, September 24th, 2024. I also submitted and initiated a PIA request directly to Baytown Police Department on September 30th, 2024, to which they requested multiple follow-up proofs such as the judge's order that I am attached to the case, which although I feel was unnecessary, I still provided all documentation. As of today, Baytown has not responded to my requests.
What would you like?
Judge, we are asking for a suppression of the blood analysis. And also, there's also surveillance that was alleged from complainant, which has never been provided since today's discovery compliance. I'd like to set this case for trial and to notate that those things will be kept out due to discovery violations.
My only concern would be as far as the video is concerned, what if there's something that's exculpatory? You know, if they, for some reason, somehow they accidentally get it, I guess we can always do an in-camera inspection, see if there's something exculpatory and go from there. And I can advise you and we can, okay, response?
Judge, the only thing I would say in this case is the state believes that we've made diligent efforts to obtain the search warrant. I would oppose suppressing that at this point only because of all of the efforts that we've taken. I understand defense's position, and they've done their due diligence as well. It's not the state's intention to unfairly surprise defense in any sort of trial setting in this case. All we want is what's fair.
Sure.
And the blood itself, you know, could be exculpatory to the client depending on what the blood discovery shows, which we also don't have. And, you know, at this point, I would oppose suppressing that now. And once we go towards trial, we can always suppress it before the jury's sworn in on motions in limine. That I would understand, but at this point, I think it's too early.
I don't agree. I
Yes,
think
Judge.
that if they haven't complied with discovery, then that's it. That's why we have it, you know, for that very purpose, you know. So I agree with you. Okay. So at this point, I guess we'll just be ready for trial. And have you already picked a date?
December 3rd, I would have liked earlier, but I think the state requested a little bit later for December 3rd, is that correct?
Yes, that's correct.
And I'm okay with that as well, Michael. If that's what you're okay with.
And
then
that's only
sure.
because, Judge, one of our.
You
witnesses-
don't, it doesn't matter.
Yes, Judge.
It really, if that's what you guys want, let's do it. I'm happy to do it. Okay, anything else?
Nothing from the state, Judge.
No, Judge, and I'll try to get my motions from limine to them to outline stuff so ahead of time, not on trial date.
Okay, great. All right, guys, thanks.
Thank you, Judge.
Thank you.
All right. Thanks, Ramona.
You're welcome, Judge.
Can we talk now?
Good, good to see you.
You too.
We can talk now.
It's new.
Love the decor.
Nice tie, dude.
Try to be festive.
Yeah. I don't even know if this is possible, Judge.
Anything's possible.
I heard through the grapevine that you.
Just advisors, the next she ever takes off again, holy moly, I'm gonna go nuts on the
I
ball.
understand, Judge.
Nuts.
Yes, sir.
Okay, thanks, hon.
And Your Honor, if I may, for Ms. Advisor, I do see a bond with her signature on it from September 23rd.
I know, Alex, I know.
But it does have the location of the Memorial City Mall. That is the location where the offense occurred. Because I misread, she used a Target bag, but it was Memorial City Mall.
Oh, Miss Visor.
Yes.
Oh, I thought you were talking about the other.
No,
one.
Your Honor, Ms. Visor, yes. So she already has signed bond conditions to not go back to the location where the offense occurred.
But when they post a new bond, we have to do new conditions.
Yes.
Don't go to the
So,
mall.
Yes, Your Honor.
how's jail? Well, when you don't take off, what happens? We're not asking for much. All we want you to do is show up. And-
Judge, wait, can I speak?
No,
No, don't.
I got you.
I showed up.
She showed up, Judge. It's a new case that brought her back. It was a new case filing for.
Oh, she picked up a robbery.
Yeah,
That's right.
and that's what we said
Okay,
the
my
bond-
fault, my
You're
fault.
good. She has shown up and her bonds are posted. So as soon as she goes back,
I don't know if this is better.
no, it's not, but.
Picked up a robbery.
No, but
Don't say more. Look,
Got you.
look, Miss Visor, just be nice. It's not hard. That's all we're asking. If you pick up any new cases,
It's kinda
holy
hard.
moly, I'm gonna lose it. Don't pick up any new cases. You've made bond again now. The only thing I'm asking you to do, don't go to any Target and don't go back to Memorial City Mall. I'm making that a condition of your bond. Do you understand? If you go back to one of these two places, the bond goes, okay? That's all I'm asking. And be nice.
Do that again. Do that
You
again.
have a
Judge.
lawyer, stay in contact with the lawyer. They will tell you when you have to come back to court. If they tell me they can't get a hold of you because you're taking off, no more bonds. I'm gonna revoke it and I'm gonna raise it up. Do you have any questions?
No, sir.
Okay. You're on the robbery case as well, right?
Yes, sir.
Okay, we can give you the same date as that robbery case as well. And then,
I got it.
yeah, this case isn't too old, so, okay, ma'am.
And her bonds are posted. She's getting cut out as soon as she gets back, so.
Okay. All right, Ms. Visor, good luck.
Thank you, Judge.
All right, but wait, Deputy Anderson, she needs to sign. Okay, Brandon, you ready? Okay. Doug, hey,
Deputy Hernandez Rubio, and we finally received the last letter for our mitigation package this morning, so
wonderful.
we're running a little bit late. She's not here.
Okay.
I don't believe she's here.
No.
But we'll have it all wrapped up here fairly quickly.
Well, she needs to do a TRAS.
Right, we have to get approved first to get the TRAS.
Okay, so let's set off maybe 2 weeks just to get the approval, and then we'll have her come back to the next setting. We'll send her to the TRAS, yeah?
Thank you
Okay,
very much.
all right. Brandon, you ready?
I like the decorations, by the way.
Thanks.
Very significant.
Trying to be festive, you know? Okay,
I'll meet you up there.
come on.
This one.
Doing all right?
Doing all right. Recovering from my TV surgery.
Oh, no.
Yeah. I'm doing great though. Yeah, yeah.
This part is really good. Just wait for it. What is a big amusement park near Houston or in Houston?
Hi, Chris. Hi, Chris. It looks like you're good to go.
I tried to access his medical records, but I got in trouble. No, is that a real thing? Funplex? I don't know if that sounds good or not. Funplex. Okay, I'll try Funplex. Is there a Six Flags in Houston?
Yeah, I'll put a time to go.
I'm good with it. I want to see the ride. Oh, that looks Bowling parties, birthday parties. That could be a bar, beer. But there's no
Yes, sir.
like roller coasters. I mean, I see a Ferris wheel, but that is not a roller coaster. 6 flags. All right, that's good. Doesn't his chair look nice? You should watch it for a bit. Moody Gardens is a better place for you, Ozzy.
Yes. You want to.
What? There's a 6 Flags in the Netherlands? That's crazy. I didn't know that.
Oh, yeah.
Do you have rides that look as fun as the judge's chair?
Lopez, Austin. Yes. Okay. Let's see.
I can't do it, Linus. Can't do it. I'm already done. I was going to chair watch for 20 minutes. I was going to try to chair watch for 20 minutes because this is what the judge does to us every day. Every day last week and this week, he's been helping out in court 10. So he just leaves for a while and we just sit there and watch his chair. And I tried. I was going to do 20 minutes of chair watch today and I'm done. I can't. Yep, we just sat there and watched this chair this whole time. Just chatting with each other, watching this chair.
Guys, when is the last time Mr. Mendoza has taken a test with us? Yeah. Thanks for coming back here.
Was September 26th.
And what was
It
it?
was a no-show. Well, that was a no-show. So no, nothing.
Come up, Mr. Mendoza. Oh, okay. Hold on a second. No. Go back. Let me talk with Mr. Roach. No, 926 is the one that he didn't show, and that's why he's here now. Prior to that. No, on both cases, no prior test?
I'm in the mood for animal
Morning, Mr. Roach.
Morning.
How's jail?
You guys
Not
all
so
have animal
nice.
crackers.
Good. That makes me very happy. The worse of an experience you have, the more likely that you'll have to finally listen.
Yes, sir.
Why did you miss court?
I was in Galveston County Jail,
What?
evading and resisting. I walked into
I don't want,
a.
facts of the
Sir.
case make no difference.
Yes, sir.
I need to know is why and why you keep picking up cases. Do you have a drug issue? Is that the problem?
No, sir. I am homeless.
Why?
Well, I have, I'm on disability and,
Tell me,
just,
where's mom and dad?
my dad lives in like Jackson with my stepmom. My mom lives in Lake City.
In League City?
Yes, sir.
Why don't you live with either of them?
Well, I would if I could. I would like to.
Why not?
Maybe I could ask, I can go to my brother's house, I'm sure.
No. Why would you not live with mom or dad?
Because I'm 30 years old.
So after law school, you know what I did? Back and live with my folks too. And I was, God, how long ago was that? Not too long ago, right? 20 years ago. God, it's been that long. 50
20 years.
But I was in my mid-20s too, and I went back to live at home. There's nothing wrong with that.
So
Or will they, I mean, the question is, will they let you live?
I think so, but I could ask and maybe so. It's possible.
Because I'm gonna tell you now, me, I'm not letting you out to live on the street.
Sir.
It's not gonna happen because chances are you're gonna do whatever you can to survive. And that means probably picking up another case and it's not gonna happen.
Sir.
Believe it or not, I want to help you as much as possible. And
Can I ask him one question without going into the details, just because I need to tell me this? Are those Galveston cases still open or are they resolved
They're open. I'm on a PR bond.
on both of them?
Yes, sir.
Okay.
How many cases does Mr. Roach have?
That is what I'm looking for right now, Judge.
No. Until I know that he has stable housing, I'm not letting you out. You now know that no one in this world is going to bond you out. So when you go to jail, you are stuck like Chuck until someone either mysteriously and magically gives you a PR bond or you plead guilty. And I'm going to tell you now, I'm not going to let you just plead guilty to get out and ruin your life. It's not going to happen. We're going to do whatever we need to do so that you get your life straightened out. And if that means sticking you back there until we get to your folks or whoever it is, that's it. No more street living. That's it.
Your Honor, would you consider lowering his bond to around the same amount as the felony? So that if one of his family members does post bond and has to go through the bonding company, that they're not out, hundreds of dollars?
I'm happy to do that. And I'm happy to set it at $100, but I want to know first that mom and dad or someone is going to have the wherewithal to let him come in. And so he has a stable place to stay. So I will do it, but I want to talk to folks first. And I think that what we can do is probably roll it to tomorrow. And then if you don't mind giving your numbers to Greg, and we can try to reach out to them to see who, hopefully someone is ready to take you. But street living, it's not going to happen, dude. And I'm going to tell you now, if we let you out and you get to your house, either mom, dad, brother, whoever it may be, is nice enough to take you in, and then you take off because you don't want to follow their rules, I'm not letting you street live. It's not going to happen.
Sir.
That's it. Typically, what I see is that people would rather party and live on the street than follow rules and get a job. Is that what the case is here, Mr. Roach? Then why live on the street?
No, because I don't even really want to explain no more. I think you know. It seems like you do. So I'm kind of done talking about it respectfully.
And I'm going to tell you now, Mr. Roach, that you've been in and out of jail now here for.
He actually looks way more 30 than the 30-year-old we had earlier.
About 2, maybe 3 years. And I'm going to tell you, in the blink of an eye, this quick, 15 years have passed. And then if you keep the hard living, you're going to look like a Quasimodo looking MF here. At 30, you're going to look like you're 71. No prospects. Okay. 41, looking like you're 82. Because the hard living, as you see, like those pictures, this is what you look like on meth after 15 years.
Or 15 years of process, huh?
Yeah.
Crooked process.
Are you blaming me?
Well, I don't know who you is.
Just my name right there.
I ain't choose this life. This life chose me.
Really?
Really? Really, really.
Okay, let's stop.
It's easy to change. Okay. The hard part is keeping the change. And I will help you as much as possible. But I'm going to tell you now, I'm not throwing you out here and I'm not throwing you to wolves so that you can end up like that. And I don't care if you get mad at me, kicking, screaming, it makes no difference. But that's it,
sir.
So
going with the flow.
You want to roll it tomorrow and see if you can reach out to someone and see if they'll take?
I'm not sure I can make a phone call, but I know my brother let me live at his house.
Okay, I'll call your brother.
Okay.
Yes, we'll roll you tomorrow. I'll bring you back tomorrow.
Thank you, Judge.
But if his brother's like him, you know, hopefully we can find, you know.
Let me talk to his brother, see if they're willing to bond him. Okay.
Thank you, Judge. Thanks.
Judge, may I approach on Gilbert? Oh, I'm sorry.
Sorry, John. Come up, Mr. Mendoza. What are you doing with yourself?
Guys. I gotta tell you. Tokyo, gave me the best 9 minutes of my day today. Hold on, just give me 2 seconds to get this link. I'm telling you, this video is top quality, 9-minute long video. Hold on. I'm going to my history. I could just go to his site, but you know, I didn't watch any of this stuff. What is going? Here it is. Oh man, it is so good.
The following program presents a
Here it is. Yeah, Tokyo tripled all the other men in my life. It's so good, guys. You can't take your eyes away. Go watch this video then, or now. I don't care. It's so good.
These days, Mr. Mendoza?
I'm working still.
Where?
I just got a new job at a barbecue place. It's called the Pit Room.
How long have you been working there?
In like a month or so. Like, but I think I'm gonna go to 2 months.
Do you remember why we revoked his bond in the first place? Was it because he picked up the felony?
I think it's just the felony. I don't think he ever missed court, but I'm not 100% on that.
Y'all gotta go there and watch it.
No, it prior to the drug test and failure to appear, we revoked his bond and set it at 20,000. And I think it's because this was right. You were charged with reckless driving. I ordered you not to drive and you signed an affidavit promising me you're not going to drive. And then you pick up an evading arrest in a motor vehicle. So I set your bond at $20,000. Now you have a positive test for, well, first off, you refuse to take the test. And then now your test is positive for weed. It stops today. The next time I have to revoke your bond, and I don't care what the reason is, Mr. Mendoza, I'm going to triple, if not quadruple, both of them. Do you understand?
Yes, sir.
You are not to smoke weed. You're not to consume alcohol. You're not allowed to drive. If you drive, that is the worst possible thing, because then I'll have a contempt hearing and then you're facing 180 days. Do not drive. No more smoking weed. I will test you 40 days from today. And if you test positive for weed again, I'm going to put you in jail. Do you understand? Likewise, if you test positive for anything else, whether alcohol, any dangerous, illegal drugs, do you understand? Okay, I'm going to reset it begrudgingly, set you off for 40 days. It's not going to happen again. Any more violations, you will stay with me. Okay, all right.
I have a question about that. Okay.
If you stop and don't smoke anymore in 40 days, you'll be a negative. You will provide a negative test. If you have another positive test, that tells me that you've continued to smoke, and that's it. John.
Yes, Judge, got a late appointment on Mr. Gilbert. It looks like I'm taking over for Carl.
In custody or on bond?
I believe it's on bond.
I think we're about to see a tiny turning point with the judge. Like, I think we're about to see people who are messing up more are going to jail. I think he's definitely keeps saying no more catch and release. It's done. It's over. I don't think he's joking. I just don't.
We'll still keep it waived. Yeah, for sure.
That's a cool little time.
How are you, Mr. Gilbert?
I'm good.
Nice voice.
I'm sorry that we had to put you in jail, but you didn't do anything.
Yeah, I understand.
You know, the first thing I asked you to do was put a monitor on your ankle, and
Yeah.
didn't even do that.
Yeah, I made a phone call and stuff and went to work the next day and I missed the date. I was like, man, if I go back there and send me to jail, I might as well just wait for my court date. So I was gonna come to court on the 30th, but you know, I was gonna try to save up some money and put in my books before I get here. Didn't know y'all gonna put.
Okay, look, I don't know what we're gonna do. You also have the felony harassment upstairs.
It's a
Looks
long
like that's a
drive.
new, oh no, you picked that up?
No, that was all the same day.
It's all the same
Oh, same
transaction.
thing? Okay, all right, no, we're in October, that's right. Okay, the felony case is set for the 30th. I guess we'll set you for the next day after Halloween, right? And then we'll figure out what's gonna happen and then we'll see. You realize I can't give you a PR bond, right?
Yeah, and I appreciate the first one. Yeah.
So, right, I can't, because then that means that we're
Yeah.
saying it's okay, so, and it's not. Just so you know, I've given you a lawyer. It's gonna be a different lawyer this time because the other guy got off. So I have Mr. Duong representing you. He's gonna talk to you in the jail and then we'll just set you off for the day after the felony court. And then we'll try to work a global resolution so it all takes care of it one time. Okay, questions? Okay,
Mr. Gilbert, this is Attorney John Duong. I will come by the jailhouse and visit with you, okay? So just
Okay.
hang tight until, talk.
Okay.
John, you're welcome to set it for another day here. That way you don't have to go all the way to the jail if you want.
Yeah, no worries, Judge. We could take care of that.
Johnny D.
But,
Whatever you
I'm-
want,
I'm-
just tell Dick,
You got it. Thank you, Judge.
Okay.
Mr. Gilbert, I'm on your case. I'll do my best to help you out, okay?
Thank you. Have a good day, sir.
All right, you too.
What day do you want, John?
It doesn't matter, Judge. I mean, one day.
You want it a different day so to talk to him, or do you want it after the felony?
After the felony sign, Judge, I'll go talk to him in jail. It's probably easier that way.
Okay, man.
Okay, thank you, Judge. 10:30 first it is.
Okay.
Thank you. Have a good day, Judge.
Mr. Brasher.
Yes. Hey, Judge.
Hey.
Hey there.
Who do you have again?
I have Galindo.
Keep your eyes on the road, Donald. If you get tired, eat ice. Eat some ice. Oh yeah, caffeine. Caffeine is a good thing too.
Come up. What? No, for real? What do you test positive for? You said everything?
Everything.
Stuff.
Yeah, a bunch, a lot of stuff.
That's positive for.
Mr. Galindo.
Yep, you said everything. That's right.
It's been a hard. It's a hard year. It was a hard year. Got out of jail February. I lost my grandma. They're trying to sell the house. That's why they put cases on me. They offered me 30,000. I didn't take them because where am I going to live? So I don't know. It's been a hard year, man.
But it's really not though. It's mind over matter, Mr. Galindo. Mind over matter. You should be able to overcome these things and not have to always turn into dope. You know, you have issues, if you're stressed out, if you're having a bad time in life, running to dope, that's not the way. You find another outlet, like working out, running, boxing, playing bat, anything is better than doing this. You can, look at you now, man. I could tell the moment you came up here, I knew something was up. You know what I have to do now, right? What do I got to do now? What?
I don't know.
You staying with me?
What is it?
You staying with me?
Where? Oh,
Jail.
jail? Well, I don't care about no jail. I lost my grandma. I don't care about no jail.
Mr. Why?
I don't.
You should.
I don't, sir. I lost my grandma. I'm telling you, trying to tell the house. I ain't even care.
Who else do you
I
have in your
just
life?
think- I got my sister.
Well, then that's something to.
I got my sister straight up.
Isn't it?
Yeah, but I'm really coming to jail. I lost my grandma. Any other shit is irrelevant.
Do you think that your sister would be proud right now?
I already told her. She's mad.
Right.
But
And she should be, because that's next time when you're in this, you think of your sister. Hey, if I do this, would my sister be proud of me? Would she be upset? That's what you need to think about.
Yeah, it was too much for me.
Monica, you talking
Can I go
about
now?
Darcy?
I'll take you now. Hey, I'm gonna wish you good luck on the next 2 to 3 days, because coming down. So good luck, Mr. Galina.
Poor guy.
Judge, we had him set for the 24th. Should we keep that date? Or do we need to do a bond review or get a bond set?
No, so the felony is set for Edwards.
2532744.
Yeah. You are Lamont Edwards. Mr. Edwards, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On October 6, 2024, officers were notified by bystander that an individual was unconscious behind the wheel at a light in Harris County, Texas. Officers observed the defendant's motor vehicle stationary in eastbound lanes, not moving for several light cycles, while other vehicles went around it and honked at times. Traffic stop initiated. Officer observed defendant unconscious in driver's seat with engine on, running, and motor vehicle in driver's foot applied to brake. Officer observed cloudy yellow drink in clear plastic cup and front cup holder. Officer turned motor vehicle off and attempted to wake the defendant. The defendant woke up and was made aware of his whereabouts. Officers observed strong odor of alcoholic beverage and red glassy eyes. Defendant stated he was on his way home, was unaware that he was unconscious at the intersection, and that he consumed 2 margaritas at a party. SFSTs conducted, HGN 6 out of 6, walk-in turn 4 out of 8, one mic stand 3 out of 4. DIC read and consented, result 0.081, 0.081.
Can you look to see if you need anything prior to DBIs, please? Prior to DBIs. Mr. Edwards, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any kind of illegal drugs, I will revoke your bond, put you in jail. You will not get any more PR bonds. Do you understand? Do you have valid Texas driver license? Do you have valid liability insurance in your name? Are you sure?
I ain't arguing
You
with you.
sure?
I'm not stupid.
No, mine just actually.
Okay, then you're not allowed to drive. I'm making it a condition of your bond until you have liability insurance in your name.
You tell me that's blue and I will cut anybody who says it's not.
No driving. If you drove here today, you cannot drive home. Do you understand? You will be signing an affidavit with me. This is a document that you're going to swear to me. And if I find that you violate this, you'll be facing 180 days in jail and a $500 fine by a contempt charge every time you drive. If you want to drive, go get liability insurance, show us that you have it in your name, and then we'll allow you to drive. But until that point, sorry?
That's it.
No, you have to bring it.
Okay.
Show it to us.
It's red, but
Yeah.
I mean, I don't ever check the fax machine, so if a fax came here, I'd never see it. Maybe perhaps someone else does.
I'm faxing him. I'm faxing the judge. Someone give me a fax machine. It's all right. I'll find one at Staples.
The other thing I'm going to tell you is that this is a DWI. There's lots of timing requirements with the DWI. And if you don't talk to a lawyer quick, you may have bad collateral consequences. So we're going to reset your case today to give you time to talk to a lawyer. I would do it quick. Don't wait a month or two because you're really only hurting yourself. So I'm going to have you come up here, swear to us that you're not going to drive. I'll get you to Victoria sign a reset. After that, I'll get you to pretrial where you'll get your bond conditions. And after that, you'll be free to go. Okay? Please. Did you say we have another? Well, I'm not gonna wait, dude. It's 1:30 and it's time to jet. Yeah, I gotta fix my garage now again. It's still broken, so. Yeah,
Page 7. Durham. So council showed up. Council showed up.
this is what we're gonna do, Mr. Gonzalez. I'm sending you now for a drug test and you must come back tomorrow with your lawyer. Do you understand?
Yes,
You already had 2 times that you have failed to appear. And I'm not in the business of giving PR bond after PR bond after PR bond. So I'm done with that. So what we're gonna do is I'm resetting your case for tomorrow. I'm sending you now for a drug test. You must come back.
Do not worry. While he's in court talking to defendants, everybody in chat in a couple minutes will say, hey, Judge, did you fix your garage?
Here at 8:30 in the morning. Do you understand?
Yes.
Okay, so we'll reinstate for limited purpose of the drug test, and then he's gonna come back tomorrow, and then we'll talk about the bond tomorrow. SFBF tomorrow, please.
They are asking about the AC.
All right, go ahead and sign.
We did it. We did the whole docket. We did all of Judge Fleischer's docket. Michael, will you please go over there and fix his garage? Michael. Anyway. Thank you guys for coming out. Yeah, well, you're ready. You're already awake. It's not like you just rolled out of bed. Go fix his garage. He won't even know you're there. Just I'm sure he has no cameras, or maybe Steven lives there though. I'm gonna send Michael to the judge's house and Steven's gonna tase him. But wouldn't that be fun to talk about later on Tuesday when you're not gonna show up? Do you have to work or kids? Anyway, where's my outro? Thank you so much for coming out today, guys. I really appreciate it. I do. Be good. I'll see you in Judge's courtroom in a few hours. And can I get 2 witnesses? Can I get 2? Wait, I'm sorry, my hands. Can I get 2 witnesses? Y'all gonna sit there? Mr. Stewart, I'm gonna Google him and see where his cases are. Yeah, maybe we'll get an update soon. I thought he was coming on September 9th and he didn't. It was a different subset. But his case had something in there on September 9th. Tina, thank you. Who got it? Granny of 9. Jeez. She needs a membership. Oh, I think I have a members only video coming. I gotta go. I gotta get this together. I will talk to you all later. Thank you so much. Be good. Behave. Thank you, mods. I appreciate it. Bye.
Got this life that goes digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late at night when the world sleeps, she's the a summer's bloom. Her humor dark and twisted, sharp. In a way, there's no alarm. Freedom tales late into the night. Her
Look at I Hunt You talking. Hey, I Hunt You. That's nice. That's like triple what you said yesterday. I saw you say goodbye.
laughter feels just right. Even when my world turns gray. With a giggle, she lights the way. Her eyes near a sky so blue. In her jokes, there's a truth so true. With each string, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted, sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray. With a giggle, she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted, sharp. In a way, there's no alarm.